transformation. To meet these needs, the National School for the Judiciary launched a program in 2024 called the Advanced Digital Cycle, in French CANUM, in collaboration with l'École des Mines, engineers, and la DINUM, the French Direction about Digitalization at the Ministry of Justice. This year-long program aims to train magistrates in the digital transformation of the judicial system, and we have several objectives in this training program. Understanding digital issues and knowing how to manage technological tools, using technologies like artificial intelligence, machine learning, blockchain to facilitate case management, and developing a synergy between justice and digital transformation at the state level, enhancing judges' ability to navigate this technological environment, because the difficulty for judges and prosecutors is to be sort of project manager in the digital transition, and you have to learn how to deal with this kind of transformation. This training concludes with a certification that highlights the participants' digital skills. France is not limiting itself to a national approach. The ENM also participates in European judicial training programs, collaborating with the European Judicial Training Network. The goal is to foster a common digital culture among all European judicial actors, which is essential for smooth cross-border cooperation in an increasingly digital world. The cycle of training sessions organized by EGTN Digital Work Group will give the opportunity for participants to obtain a certification called the Digital Passport. Starting also in 2025, the ENM will lead the European project called Just Fair, which aims to adapt judicial training to generative artificial intelligence. This project, in collaboration with European partners like our counterparts in Spain, will focus on ways to use AI to improve the quality and speed of judicial decision while respecting ethical principles. Its goals will be also to understand how to train with AI and how to use AI in the training of judges and prosecutors. In conclusion, the digital transition of the French judicial system is a profound and essential transformation to modernize justice. The PPN and the use of AI promise to improve the efficiency, transparency, and accessibility of justice to all citizens. However, this technological revolution also presents challenges in terms of training. Initiatives such as the CANUM and international cooperation projects show that legal professionals are preparing to meet these new challenges. The future of justice will be shaped by innovation, but it will also require continuous adaptation of skills to ensure the integrity and efficiency of the judicial system in the digital age. And thank you for your attention. I think that I can
I think, yes, you are best placed to win the challenge of the timely presentation. Indeed, it was very efficient. Thank you very much, Emmanuel. And now we are going to hear the lawyer's point of view with Giovanni Greco, who is a state lawyer in Italy, and who will also share some insights from the lawyer's point of view.
Yes, hello, my name is Giovanni Greco, and I'm a lawyer of the Italian government. And I deal with the procedural defense of the Italian government in front of the European Court of Justice. Unfortunately, in a short time, I have to going away to take the ship to Naples, so I will be very quick. And my short speech today focuses on the standardization of judicial acts in front of the European Court of Justice, also in relation to the digitalization of the process in Italy and the document standardization in the process, in the digital process in Italy. As we all know, the EQR program is the pioneer of digitalization of process in Europe. Is the first and the most important justice digital program that we know in Europe. We all know the convenient and efficient that digital e-Cura program that regulates the process in front of the European Court and represents, in my opinion, the most significant implementation of the fundamental principle of maximum participation of all the states in the European Union in the process of in front of the European Court. In fact, is extremely simple for government representatives to digitally deposit their written observation and, above all, to know the content of the observation deposited by other parts. The e-Cura program is also the first digital program known to the international judicial system that provides for the standardization of judicial documents. The univocal nature of the drafting of judicial documents constitutes a fundamental principle that allows for order in the judicial activity and most of all allows the court to immediately and clearly understand the fundamental passages of the defense documents. Finally, I would like to underline how the standardization of documents in the process allows all the parts to eliminate all those parts of the defense documents that could otherwise be superfluous or even be against their thesis supported by the parts themselves. As Gianluca Grasso said before, in Italy, even though there are still some problems to be solved, the digitalization of the process has reached in a good standard. But the standardization of the documents is not yet foreseen. All parts can write judicial documents as they want, with no pre-filled formats, and as in the e-Cura process. But now, the judicial system will begin to borrow from the Cura this drafting mechanism in the administrative process. As Marina Pellelli will say in a few minutes. In fact, not only at me, but it will be the first, more or less in 2025, I think. In fact, a regulation is being drafted that provides for the standardization of judicial documents in the administrative process, which will presumably can come in force in 2025. Thank you for your attention, with the hope of meeting you soon in person, and thank you very much for your attention. I have to run to the harbor. So, thank you very much. Goodbye to all.
Thank you very much.
Bye.
So, this was a very efficient presentation indeed, and it's the perfect transition indeed, because we usually miss a little bit the administrative process, and we are lucky enough to have the last speaker of the day, who is Marina Perelli, who is State Chancellor in Italy, and will also provide us with insights related to digitalization.
Thank you. I'll be really short because I know that I am the obstacle to a wonderful work in Capri and the Apero, and so I don't want to bother you about the administrative system. So after this big picture of digitalization and the AI in Europe, I have just to outline what we are experiencing in Italy in terms of digitalization in the administrative justice. And I would outline, if it's possible, if I have just 8 minutes, not more, 3 main points. The first one is a brief introduction about the telematic administrative trial. The second one is the strategy we chose about the use of AI in administrative justice, because we are working on innovative system, and so we considered how to use artificial intelligence in administrative justice. And finally, I would like to share with you some law cases related to the review of the administrative judge on the algorithmic administrative decision. Because it's, I think that we established some principle that we can maybe we can apply also to the judicial decision-making process. So what about the telematic administrative trial in Italy? Since 1st January, the telematic administrative trial has been active since 1st January 2017 and has been operational since 1st January 2018. It means that we are totally paperless at the moment, and because we don't have paper, and we have just all files are digitalized. All the process is digitalized in first and second instance. And this is also the reason why we could react really quickly to the change due to the pandemic crisis. So you can carry out digital file 20 hours a day, 7 days a week. So, I mean, we are really proud about our telematic, our digitalization, but we continue to work on innovative system, and we continue to work on the use of AI in the administrative justice. And I would like to focus on the project for the implementation of the Administrative Justice Data Warehouse, the WH system, which for statistical analysis capacity by introducing constantly updated and effective business intelligence processes. And this will allow more reliable forecasting of trends and optimization of queries with more immediate identification of critical issue and stage where they are concentrated. And which is the final aim? The final aim is to achieve a true data analysis platform based on data-driven logic. But while we were working on this kind of system, we identified the need to develop a strategy about the use of the AI in administrative justice. And after a really careful and in-depth reflection, we chose the idea of enhancing the positive effects of technologies because we are sure that they can help us on the organization of our work and on the effectiveness and the efficiency of judicial activities, but we chose to give to this technology an instrumental role. And so this is the reason why I think that it's more accurate to speak of augmented intelligence rather than artificial intelligence. This is the I mean, this is our choice. Maybe it's not true. Maybe it's, I mean, but we did this kind of choice, and we think that it's in line with the European Ethical Charter on the use of artificial intelligence of justice systems and the environment adopted by CEPEJ in 2018. And also we think that it's in line with the new regulation of AI adopted in 2024, because the so-called AI Act distinguish the use of AI system in the field of justice in two different kind of system. Those intended for purely ancillary administrative activities that do not affect the administration of justice in individual cases, and those used by judicial authority in the interpretation of facts and law, in the application of law to a concrete set of facts. And I mean, we think we read a lot this new regulation, and we think that the European legislation, it's only in relation to the letter that the European legislator felt the necessity to qualify them as high-risk activity and to provide a special procedural safeguards characterized by a risk-based approach. And this is why? But because they have a potential impact on democracy, on rule of law, on individual freedom, and on the right to have an impartial judge and to have an effective remedy. And because they can lead to potential distortion, to bias, to errors, to opacity. And so about this topic, I would like to share with you what we decided, what we ruled as a Council of State about the algorithmic administrative decision, because I think that we established some principle that maybe we can they could be applied also in the case of algorithmic judgment and not just administrative decision. And the Council of State ruled that, I quote, the discretionary power of a civil servant must precede the procedure by means of a full investigation, and that the possibility of using artificial intelligence in administrative procedures depends on a fundamental factor, the full knowledge of the machine's decision-making process. According to Council of State, the mechanism through which the robotic decision takes shape must be knowable in accordance with the principle of transparency, which also implies the full knowability of a rule expressed in a language other than legal language. And so this is a decision of 2018 of Council of State. And my conclusion, so we can go to work through Capri, I think that now we have to think about new procedural laws, because the safeguards must be different for a judgment in electronic forms. It means a judgment produced by a human being, but with the help of a computer. And a judgment electronically processed. It means that the content of which is determined by a machine itself, thanks to its ability to compare and analyze the data made available to it. And because we have to, I think that we have to think that transparency, that we have to respect the fair trial and the fundamental principle of European law and of our constitutional law. Yeah.
Thank you very much. So I have a question for you. I read your decision, the decision you cited in 2018 in Italy. It is very interesting, but for us or researchers, and we study this kind of judgments, yes, it is fascinating, but at the same time, this provokes me more questions. For example, when the Council of State stated that it is fundamental for transparency to know that the decision was made also by reference to an algorithm.
Yeah.
The problem is, should I just mention which algorithm it is? Or is it sufficient? Or should I also rely to some references, for example, the statistics that allow us to understand the benefits and the disadvantages of using that algorithms? So by what do I mean? Also the possibility of winnings of that algorithms, or the possibility of losing of that algorithms. So since it is all based on a probability, and statistics, according to professor, we have one here. What should be when we talk about transparency in this case? What should be sufficient for us?
To know the order, you have to know the also if you want the priorities assigned to the evaluation of the data, because it's like and I mean we want to consider the algorithmic decision as a normal decision. Yes. And if we have a normal, when we review an administrative decision adopted by a human being, we try to know which is the proceeding and which is the investigation they did, and it is the same with algorithmic decision. But it's true that in this case the judge has to be more able to do that, because I mean, and in it's special training, because it's true that we don't know a lot about algorithmic decision, and I mean, as the engineer said, we are not so able to understand all the proceeding. But the in the case of decision of 2019, we asked that if the public bodies decide to use algorithm to decide, he has to explain the author, the procedure used for its elaboration, the decision-making mechanism, the priorities assigned in the evaluation, and the data selected as relevant. Because if you, I mean, the data are fundamental, because if you choose just a part of data, you change totally the decision, because we are the outcome. Yes. So
thank you. Thank you.
I would like to thank you warmly, Marina. Thank you very much to all our speakers for this so inspiring and rich presentations. I would like to end by mentioning indeed what was the main objective at the end, and which we are going we were confirming now at the end of this roundtable, that indeed judicial training will be and is definitely essential. It is needed because we need to understand, we must understand what is at stake, which are the opportunities, but which are the threats, and we need different trainings. We need trainings on the technical aspect. It has been said, of course, the legal training is always necessary, but technical aspect is needed, and we need also to enhance the knowledge, the skills of the judiciary to use the new tools to dive into this digital era. We also need to better understand what we are talking about. And I would like to end with that, because indeed we have been trying to talk about all digitalization. And we mentioned AI, we were mentioning tools, we were mentioning algorithm, we are mentioning many things in another language than our, because here no one is British or American. So we are also talking about digitalization in a language that it's not our native language. And we will need also, for example, a glossary to understand exactly what we are talking about when we talk about AI, when we talk about algorithm, when we talk about all these terms, software, etc. We need to understand exactly what we are talking about in order to identify the most relevant training. And here at the European judicial training level, indeed, we can gather all this expertise, all these enriching insights that you are sharing with us, because we are we are definitely on this path to deliver the most relevant training, and we are going to have a webinar in a little bit more than 1 week. And here I would like to praise especially Antonella Ciriello, who is also the main organizer of this event, because we are here for her. We came with by boat, by flight, and then she gathered all of us here, and also dived into the hybrid meeting, because at the beginning it was supposed to be only face-to-face, so very adaptable. And Antonella will be in charge of the next webinar we're organizing internally at EJTN level, because we must understand also with Paola's help exactly which is the calendar, because we want to deliver the most relevant and timely trainings, either online or face-to-face or online, or even materials, crash course, anything that can really support judges, prosecutors, and court staff in these digital transition. So if you have insights, if you think about something else afterwards, we would be very happy that you could share with us. We already gathered the expertise of partners, and I see that Stanislas is still with us. So thank you very much.
Yes, and I wish to
CJAU.
since I'm not face to face, I wish to thank Antonella particularly for inviting me at this event. I think she's in the room, isn't she? I think I can see her.
Yes, she's there. Yes.
Yes. So thank you very much, Antonella, for your invitation and for the fruitful and insightful discussions. I will definitely use all that I have learned this afternoon to feed up the teams AI within the court, because it was extremely fruitful. And I would propose to also share with you my PowerPoint presentation if you want, so that you can scroll through all the aspects that I wish to cover this afternoon. And if we can get the others presentations, I would be very pleased too.
Yeah. Thank you. Thank you very much, Stanislas. And here, Antonella, you will have the final word.
But just to greet all of you, especially Stanislas, I'm super sorry because I called you a lot of times Adam instead of Stanislas. Because you're but we are joking.
There is a famous
on this problem, and absolutely yes, we are collecting all the materials. Even if you have some other materials to give us, also by the professor, and we can put everything on our website. If you want, we can create also a little publication after this meeting. We are collecting also the other acts in Italian on the other topics, because all the topics are really connected, linked among them. Especially we spoke about the digital identity in the morning, about the state of digitalization, about the state of digitalization of the trials in each country, not in each country, in Italy, and we can also add some points about other countries, and we can speak about artificial intelligence. Why not? Learning by the simulation the professor gave us, also other professor today, especially the engineer from the AGID, the acronymous in Italian, Agenzia per l'Italia Digitale. They spoke about the danger we have to face, especially in the field of artificial intelligence, by using this system developed abroad. We need to create an in-house system, probably in Europe or in Italy, and we have to trust the system. But also we have to study a lot, to create a training system, to develop a strong literacy, which make the judges and the other legal practitioners very capable to understand deeply the phenomenon from the technical point of view. So we need a lot of your knowledge. And because also, for instance, Microsoft, we use for our electronic email, Microsoft. What we trust Microsoft, but they are not Italian, so it could be Chinese and yes. We don't, just in those few days. So we can't know if they have there is a back door. Maybe we don't know. Or our information are exactly. So we don't know. We need to become really competent on this field, which is not legal knowledge anymore, but also technical knowledge to be very professional and competent judges and public notary and also other legal practitioners. So thank you, everybody. And I enjoy Capri. There. You enjoy the idea of Capri.
Thank you. Thank you very much.
Thank you. Bye.
Bye.
Bye, Stanislas.
Enjoy Capri.
Thank you.
It will be for next time for me. Bye.
Bye.
Grazie. Grazie. Adesso tu puoi parlare.